Can go ahead and get started. I have been instructed to wait for a telephone in the back to ring indicating, all right, that we are on the record. So I'm going to go ahead and call this session of the City of Issaquah Hearing Examiner to order. For the record, today is September 24th, 2019 at 10 a.m. We have one item on the agenda today. This is a hearing on dispositive motions related to number APP 19-00002, the matter of the appeal of IHIF Commercial LLC of an administrative decision by the city. This is the third time, I believe, fourth time perhaps, we've been here on this matter or related to this matter, so I think myself and everyone involved is very familiar with the background and the issues that are present, so I'm not going to belabor everyone with long opening remarks. Just note that we had a pre-hearing conference back, I believe in August, on this matter at the request of the parties, which was very useful, and ultimately decided that we would go ahead and hold a hearing first on any potential dispositive motions and then determine how best to proceed following my decision on such motions. So that's what we are here for today. Ultimately, I received a motion for summary judgment from the appellant as well as a motion for partial summary judgment from the city. So to begin, I would say let's sort through any procedural matters that might be at issue. Mr. Lell, right before you walked in, I just had the appellant verify. If you'll recall, at the last hearing, they gave me these binders, and they assured me that there was no additional information related to their motion for summary judgment that was later submitted. That wasn't included in those binders, except for in the response, there was an affidavit. Is that correct?
Correct.
Okay, so you should have had all those materials. And the numbering, I note, is a little odd because these were gleaned from the much larger, enormous record from the matter that was heard by the Development Commission. I'm not going to change the numbering so that we don't confuse anyone. So I will accept the exhibits for the appellant as numbered in the binder that was tabbed for me. I assume there weren't any objections to the exhibits. These have already been in the record in a previous forum. And then the city in its materials, and I just wanted to make sure, Mr. Lell, I had these right. I have a C4, a C6, a C30, a C31, and I couldn't tell if the ordinance itself had an exhibit number or if it was attached.
If the ordinance you're referring to is the agreement, and that was C64, is that?
No, it's right before that. Sorry. Ordinance number 2830, body, and I couldn't tell if that was intended to be part of the PowerPoint that is labeled as C31.
No, sorry, that should have been labeled. I believe that was it's the signed copy of the ordinance that
Yes.
was actually an exhibit, and I can provide the citation to that for you.
Okay, so we'll figure out, I'm certain it's in the record, it might even be in the materials that the appellant has submitted. This was the ordinance that adopted the replacement regulations.
And I believe it actually appears multiple times. It was included as an attachment to the city's original staff reports, and there were 3 of those, one for each
Right.
of the SDPs or ASDPs that were at issue in the underlying administrative proceedings. The reference, I believe, that we used was to C-01C11. And that's, again, it appears multiple times, but that's the same document.
Okay.
Just to have that in the record.
Sure, C-01-C11.
I believe so, yes, thank you. And that's, the reference is on page 26 of 36 of the index of exhibits that was appended to the notice of decision.
Okay, so, and then finally C-64, which is a fairly massive collection here. Okay, and the appellant didn't have any objections to any of those exhibits, I assume? Okay. Were there other procedural matters that either party had before we get started? Mr. Schneider?
No.
Excuse me, Mr. Lowe?
None from the city.
Okay, so, great, that makes it easy. I believe then the best way to proceed would be, why don't we start with the dispositive motion, Mr. Schneider, that the appellant has brought, and you can make your argument. I may have questions, and then we'll have a response from Mr. Lell, and then we'll turn the tables and go the other way. Does that work for everyone?
Yes.
Great, and you're all attorneys, so I don't need to swear anyone in. We'll just do argument. This is the kind of hearing I enjoy. So I will listen, and if I interrupt to ask questions, I apologize, but I do sometimes get the inkling to do that. So thank you for being here. If you can just introduce your team for the record, Mr. Schneider.
Good morning, Mr. Examiner. I'm Pat Schneider on behalf of Shelter. Next to me is Jackie Carey, also on behalf of Shelter. Tia Heim and Gary Young, who are, Ms. Heim is the manager of this project, or these projects, and Mr. Young is one of the principals in Shelter.
Great, thank you.
So, Mr. Reeves, I encourage you to interrupt with questions.
Okay, thank you.
I would prefer a conversation.
Excellent.
I'm going to start by addressing the standard of review.
Okay.
Clearly erroneous standard in the code, and then the role that I think LUPA plays in this proceeding. The clearly erroneous standard is unquestionably in the code, and we're not arguing that you should disregard it. We're arguing that it is more than met. I submit, based on the evidence and the argument you're going to hear, that the decision was not just clearly erroneous, it was arbitrary and capricious. But the director's determination is not the city's land use decision. You will be making that, and the city's land use decision has to conform to the standards in the state law, which include it has to be a constitutional decision. The fact that you are making a decision in an appellate capacity does not exempt you from complying with the Constitution or with the other standards in state law. So all of those standards are at play here. The authority the city cited that says you can't rule on constitutional issues is undisputed. It's just irrelevant. We're not asking you to make a decision about anything except vesting that is within your jurisdiction, and we're simply asking that the decision be constitutional. Now, in applying the clearly erroneous standard, the first question is which decision, which interpretation of the director should you apply it to? And there are 4 different incompatible interpretations of the director in the record before you. The director, until publicly to us until April 4th of 2018, repeatedly said that you vest to the development agreement. We have the November 22nd email in which he said yes in response to a direct question from Ms. Heim about whether we are vested. We have his March 15th letter that he signed on the 18th acknowledging that the applications for the site development permits were complete under the development agreement. That means they are vested. We also, in response to the city's motion, submitted Exhibit 1 to Jackie's declaration, which is the letter that Mr. Niven wrote to Polygon in March of 2017, a year before he acknowledged that our applications were complete. And the second half of that letter specifically addresses the issue as to whether someone vests by submitting an application for a site development permit under the development agreement. And Mr. Niven clearly says in the last paragraph of that letter that a complete application, and here I'm going to quote, is vested and would be unaffected by any future changes in zoning or development regulations, so long as the application remains active. And he gives this quote to the city code. And then he says this would include any changes as a result of the termination of the Issaquah Highlands development agreement. Mr. Niven could not have spoken more plainly and agrees with Shelter that applications submitted for site development permits, why the development agreement is in effect before termination. He uses the word termination. He doesn't say before expiration of the build-out period. He says before termination are vested and will remain unaffected by expiration or by termination of the development agreement.
And sorry, Mr. Schneider, is that what is, I guess, S13?
Yes.
Or, okay, just making sure.
Yes, and I've been quoting from the last paragraph.
That's what's that. I just, from attachment to the reply.
Yes.
Okay, great. Sorry.
Ms. Carey's declaration, it's the first exhibit to that. So we have multiple expressions by Mr. Niven that are consistent with Shelter's position in this appeal. That changed as far as public communications to us were concerned, because again, as we demonstrated in the transcript excerpts, also attached to Ms. Carey's declaration, the fact that Mr. Niven and Ms. Sloman were interpreting the word vesting differently between themselves than the word is commonly used in the rest of the world was not revealed to us until discovery in a companion lawsuit. So on April 4th, we get a letter from Mr. Niven that says the adoption by the City Council of the replacement regulations divests you. He uses that phrase, divest. But of course, the law could not be plainer that newly adopted regulations cannot divest vested rights. It's an unconstitutional taking of vested rights. The law is absolutely clear on that. So the city apparently thought better of talking about divesting, and in the September staff reports, he says, well, you couldn't vest during the build-out period. He draws a clear distinction between the build-out, he says after the expiration of the build-out period. He draws a clear distinction between the build-out period when you could vest and the period after the build-out period when you cannot vest. And then, in the briefing, we hear for the first time ever, it doesn't appear in any case, I've never heard the phrase before this hearing, we learned about the concept of non-permanent vesting, which is an oxymoron if there ever was one. The whole point of vesting is it continues when the regulations change. The right continues. The concept of non-permanent vesting is anti-vesting, another phrase that we heard for the first time in the briefing, in this case, in the reply that was submitted yesterday. So the briefing now is putting forward two inconsistent, incompatible concepts, frankly, in one case on the same page. The briefing that the city is submitting to defend the director's shifting interpretations, in one place says, here I can give you specific quotes, right now I'm referring to page 10, lines 10 through 12 of the city's response to our motion for summary judgment. The director says the build-out period is the vesting period. In footnote 6, in that same response, he says applications submitted during the build-out period do not vest. So we're getting contradictory arguments in the same brief, that the build-out period is the vesting period and that you never vested, because now we learn that the vesting section of the development agreement is in fact an anti-vesting provision. So in both the city's motion and in its response to our motion and in its reply, in all three briefs, it is asking you to accept and agree to two inconsistent concepts, that A, there never was any vesting, or B, there was non-permanent vesting that arose during the period between the end of the build-out period and the termination of the development agreement. So again, we're talking about deference and clearly erroneous. which of those decisions are you supposed to decide is clearly erroneous? And I submit, because they are all incompatible and inconsistent with one another, all of the interpretations that followed his clear articulation of vesting before expiration of the development agreement, before its termination, that none of those interpretations are worthy of deference. And in fact, that they contradict one another, that they are evolving, that they are changing, demonstrates that they are more than clearly erroneous. Now, the city in its response and its motion purport to take Shelter to task for basing its argument on case law and not on contract law. But it's a remarkable assertion repeated many times by the city, because our motion for summary judgment cited 15 contract cases in support of the motion. And if you read the footnotes to our motion, they constitute a pretty good treatise on contract law as it applies to this case. And I'm going to take just a moment and quote a few of the quotes that are in those footnotes, starting with footnote 35, which is on page 7 of our motion for summary judgment.
Mr. Schneider, can I interrupt for just a moment to make sure I understand the initial argument you just made about, it seemed that there were two arguments. One, it's unclear whether any deference is due because the city has essentially shifted its interpretation of what vesting means on 4 occasions. Is that the basic?
Well, there are a couple of concepts
Yeah.
that I pushed together there.
Right, I want to unpack it just a little
Yes.
bit so I'm clear in my
So,
thinking.
again, because the city has shifted and is, and I think is at present maintaining at least 2 incompatible arguments, you have to decide which interpretation
Right.
you are going to give deference to. So that's the first question. But then, having decided which interpretation you're going to give deference to, and the one that is technically before you is the one that is in the staff reports from September. That's what we were finally able to appeal. And it's in that interpretation where the director takes the position that there is a difference between the build-out period when you can vest and the period after expiration of the build-out period, but before termination of the build-out period when you cannot vest, or rather you vest, but then the vested rights go away because they're non-permanent rights.
Right.
So I think that is technically the interpretation that you are supposed to make a decision about. But the fact that the city has made so many different interpretations that are compatible with one another, I think is directly relevant to the issue of whether the September interpretation is clearly erroneous. Because deference, even statutorily mandated deference, is a starting point. It's not the end point, and it can be overcome by the facts and circumstances. And I think that's what we have here.
Okay,
And-
so I've got essentially the staff reports prepared by the director, Mr. Niven, and then the decision of the Development Commission itself has findings on vesting.
Yeah, I don't think it makes any direct findings on vesting, other than that the director made a vesting determination. But they accepted
The directors, yeah, I mean, there are 1, 2, 3, 4, there's almost 2 pages on vesting in the Development Commission decision,
But I don't think, again, the vesting determination was made by the director.
Okay.
Those findings, I don't believe, are directly relevant to the issue before you.
Okay.
And again, the law is clear, the case law is clear, that the Sleesman case, the Cowiche Canyon case that we cited, that a court is going to give deference only to an interpretation that is an established policy of the agency at issue. We clearly don't have that here. We have shifting interpretations. We have, black and white differences between what we were told before expiration of the before termination of the development agreement and what we were told after. So under the case law, Cowici and Sleesman, a court is not going to give any deference. And but I think for purposes of your review, the issue is the clearly erroneous standard of review is overcome by the facts and circumstances before you.
Got it. Okay, thank you for unpacking that. So now if you'd like to move to the case law as you were just about to.
Yes, so again, I think 4 or 5 footnotes are worthy to call out here. So beginning with the footnote on page 7, footnote 35, it's a quote from a 2015 Division I case. Quote, "It has long been held to be the universal law that the statutes and laws governing citizens in a state are presumed to be incorporated in contracts made by such citizens because the presumption is that the contracting parties know the law." And similarly, shifting over to footnote 46, we have the Washington Supreme Court in a 1996 decision saying contractual language also must be interpreted in light of existing statutes and rules of law. So we're talking about a contract that was entered into in 1996. The law of vesting and vested rights was well established. We submitted, in support of our motion, 11 vested rights cases that were decided before 1996. So when the parties use the word vesting under the authority that I just quoted to you, that term and the law that gives meaning to that term was incorporated into the contract. The parties did not say anti-vesting. The parties said vesting. And so the case law is relevant because when you're interpreting a contract, you incorporate into the contract, the language as it's interpreted by statute and case law. And the case law at that point in time included the Erickson versus McLaren case decided, I think a year or year and a half prior to 1996, in which the Supreme Court made it absolutely clear that local governments can extend vested rights beyond the minimum required by the state statutes. 5817 and 1927 are the floor. Local government can go beyond that, even without the authority in the development agreement and statute, and extend vested rights. Erickson versus McLaren was clear about that. But it's also clear that the parties were talking about vesting, and vesting is not permanent vesting versus some kind of non-permanent vesting. It's not anti-vesting. It is a right that continues after the applicable regulations change. So the parties who are sophisticated parties, you have a city represented by a city attorney. I believe it was even the same law firm. You have sophisticated developers represented by big Seattle law firms. Everyone knew what the word vesting meant when they used it in this agreement.
Now, question there, Mr. Snyder. Clearly, there have been excuse me, recent in the last, I guess 2-3 years. The one that sticks out to me would be Patala Village, especially, which unhelpfully to everyone in our field, the Supreme Court opted not to take review of. Whether that means they believe it was, crystal clear in the way it was decided would be difficult to say, but they've had a few opportunities to address this issue. But arguably that case, especially Patala Village, really stresses that, vesting is no longer under the purview of the common law, and only plats, building permits, and development agreements involve vesting, if that makes sense. I know that was said inartfully. So my question for you then is, if I agree with you, everyone knew and thought they knew what vesting meant when the contract was entered into, does it matter that the law may have changed later?
Well, I don't believe the law has changed.
All right.
As the starting point for my response. And I think that it would, I think the analysis in that decision was poor, but even accepting it on its face, all it says is that you're not going to get additional vesting points other than those that are set out in the statute. But remember, the development agreement allows the parties to agree on vesting. And Erickson-McLaren versus McLaren, which is a Supreme Court decision which was not overruled by a Division I decision, clearly says local governments can extend vested rights beyond what is the minimum in state law. So Batalla Village involved, an application for a shoreline permit. I think that is, on its face, is consistent with the Erickson versus McLaren decision, which involved an applicant asserting that they vested when they applied for a master use permit submitted in the city of Seattle. And the Supreme Court said, we're not going to extend vesting rights beyond what's in the statute, but the city of Seattle is free to go further and agree to additional vested rights beyond the minimum. That is still good law. So I think all the, even assuming that the Batalla Village decision was correctly decided, all it says is that we as a court are not going to create additional vesting points. It doesn't in any way overrule the existing case law, and it doesn't in any way diminish the meaning of the word vested as it is set forth in the existing case law. It just says we're not going to create an additional vesting point as a matter of case law so that you vest when you apply for a shoreline permit. Well, that's exactly what the Supreme Court said in Erickson versus McLaren before it went on and said, of course, the city can extend vested rights if it wants to. So I think Batalla Village is completely irrelevant to the issues before you. The case law about what vesting means has not changed one bit.
Okay, thank you.
So footnote 37, the context rule. I'm going to spend just a moment with this because it is redolent of meaning for this appeal. This is quoting a Washington Supreme Court decision, contract case from 2004. The context rule requires that we determine the intent of the parties by viewing the contract as a whole, which includes the subject matter and intent of the contract, examination of the circumstances surrounding its formation, subsequent acts and conduct of the parties, the reasonableness of the respective interpretations advanced by the parties, and statements made by the parties during preliminary negotiations, trade usage, and/or course of dealing. Well, two of those examples of what you look at when applying the context rule, including statements made by the parties in course of dealing and subsequent acts and conduct of the parties, are clearly relevant to this case because we have Director Niven, whose interpretation is at issue, his latest interpretation is at issue, acting and saying things that are directly inconsistent with that before termination of the development agreement. So back before city policy changed, when it was a garden variety application of law to fact by the development director, he was treating applications for site development permits submitted under the development agreement as vested, and clearly saying, as he did to Polygon, that termination of the development agreement has no effect on your vested rights. So we have the director's own actions and own words undermining, using the context rule of contract interpretation, undermining the interpretation that the city is asking you to uphold today. And the other context is the one I mentioned a minute ago, which is that we were dealing with sophisticated parties represented by competent counsel. And we were dealing with a remarkable situation, and I'm going to come back to this in the final things I say. But we're dealing with a situation where this was not just a development agreement, it was an annexation agreement. Hundreds of acres were being brought into the city, and the developer was spending hundreds of millions of dollars up front on mitigation, on environmental review, had far more invested, far more at stake in his applications than probably any developer has ever had in the state, given the size of this project and the amount of money that was being invested up front. And that developer was entering into a development agreement in which, after the end of the build-out period, there was no requirement that replacement regulations be adopted at any point in time. They could have gone on, the city could have waited years before it developed or enacted replacement regulations. So vested rights were acutely important to this developer because of all the money they were investing up front, because of the size of the project at issue, and because the period of time when vested rights would matter after the end of the build-out period could have gone on for years. So it was a very important concept to the developer, and that has to be taken into account in applying the context rule to the statute, to this contract. Footnote 44. Courts should not adopt a contract interpretation that renders a term ineffective or meaningless. The director's current interpretation not only renders the word vesting meaningless, in fact, makes it anti-vesting, it renders meaningless the first clause in section 3.23.2. So I'm going to turn now to the actual language of the development agreement. You know, 3.23 itself in the first paragraph, which doesn't have a sub-section number on it, defines implementing approvals to include all applications submitted under the development agreement, expressly including applications for site development permits, which are what are at issue here.
I'm sorry, what was that reference?
That's 3.23, the first paragraph.
3.23.
Yes.
23. Okay. 3.20.
And I'll wait a moment.
Thank you.
It's on page 13.
Oh, very helpful. Thank you.
Okay, so again, the first sentence of
Got
3.23
it.
defines implementing approval. It's basically all permits that you apply for, but certainly expressly including site development permits. And then you turn to the next page, the first separate numbered section, 3.23.2. And let's read that. The development standards shall, it's mandatory, continue to apply to all applications for implementing approvals. That means site development permit applications, because they're expressly included, submitted after expiration of the build-out period. So the period after expiration of the build-out period is the period, in this case, from September until March, when the replacement regulations took effect. That language clearly creates vested rights. Shall continue to apply to all applications submitted during that period of time. Now, the city then says, well, the exception renders that first sentence illusory. There's no way to avoid that interpretation of the current city arguments before you. They say the exception renders that first sentence illusory because it's an anti-vesting section, and it clearly was not intended to create vested rights, even though it says shall continue. Well, there are multiple problems with the city's position. And before I move on, I want to cite one more footnote to you. It's footnote 53, where we quote from a Washington 1997 appellate decision. The court will not give effect to interpretations that would render contract obligations illusory. So why is the city's interpretation illusory? Because it says that the vesting is non-permanent. Well, non-permanent vesting is not vesting. And if you turn over, that section goes on, except, either party can terminate as provided in 5.13. So if you turn over to page 23, that's where section 5.13 is. And it's a lengthy section, but the key sentence is the last one in that paragraph. So it says, upon such adoption of the replacement regulations, this agreement shall terminate, and thereafter, the UGA portion of the property shall be governed by the adopted city zoning and related development regulations. So the city asks you to ignore the word thereafter or interpret the word thereafter to mean it applies retroactively to take away the rights that vested before termination, rendering the term thereafter meaningless, and therefore the vested rights illusory. It simply is an unreasonable, to use a charitable term, interpretation of the provisions of this contract. The city also, again, says, we're the ones, we, the director, we're the ones interpreting the contract, and you, Shelter, are reading it in bits and pieces. Well, I commend to you our motion for summary judgment, page 3 of our motion. Where we set out all of the language at issue, 5.13, 3.23, 3.232, all the language that I have just gone over with you and that the parties have briefed at length. We set them out on the same page. This is the only place in the briefing, nowhere in the director's briefing is there any attempt to actually present all of these terms together so that they can in fact be read together as the law requires them to be. And we start out with section 5.13 because it really defines the end of the vesting period. And again, as we quote on that page, the term of this agreement shall continue at a minimum through the build-out period and shall continue after the build-out period. And it says upon termination, then the new regulations, apply thereafter. So the language couldn't be clearer, and the fact that it couldn't be clearer is demonstrated by the fact that it was the director's own interpretation until his April letter of 2018.
Now, just to be clear on a factual point that I'm certain is in the record, but it's a lot to keep track of, there's 3 periods here, right? There's the build-out period itself, not at issue.
Well, except that at least 3 places in the city's most recent briefs, they say there wasn't vesting during the build-out period either.
Okay, well, let's not go there for now. I'm saying there's the build-out period, there's this gray area where the city has essentially said, the build-out period that we both agreed to has ended, and we plan on adopting new regulations, and then there's the post-new regulations period. The permit applications at issue here were in that middle period, correct? Yes. So your argument is essentially under, you believe, the plain meaning of the contract, the permits that were submitted should have vested to the development regulations. That's it. I mean, to the extent that the city had, you're not arguing the city didn't have the right to ultimately adopt new regulations that in the future would be applicable. It's that you got permits in time prior to the adoption of the new regulations.
Yes, no, obviously the city can adopt whatever regulations it wants. We have a dispute not material to the argument this morning about the effect of those regulations on Shelter's property, but the city can clearly adopt those regulations, but the city cannot adopt new regulations that retroactively deny, take away, render illusory vested rights. The law could not be clearer on that. both in terms of contract law and in terms of regulatory law.
Right, but again, the 3 permits at issue for the site development, not the plat, it's 2 SDPs and 1 other one, right?
Yeah, the plat application is
Not before me.
not before you
Okay.
in this matter.
So is it 2 ASDPs and 1 SDP?
Yes.
Okay, those 3 permits were applied for
And deemed complete
and
by
deemed complete
by the director.
after the
End of the build-out period.
we'll call that the contractual build-out period to the extent that it's explicitly stated what the length of
Yes.
the,
Yes.
but before the new ordinance was adopted.
The development agreement uses 2 different terms, and I think intentionally so. It uses expiration when talking about the end of the build-out period. It uses termination when talking about the end of the development agreement.
Okay, so the better phrase then would be the 3 permits at issue were applied for and deemed complete after the expiration of the build-out period, but before the termination of the development agreement. That's how you'd like me to say it, okay.
Yeah, so I think that's,
The city might disagree, but ultimately I get the point. After expiration of the DA, but before termination.
and those words are used in the development.
Got it.
And again, I want to make it clear that the build-out period is not the vesting period. Again, the city is all over the place in its briefing on this issue, but the build-out period is, the period is defined in the development agreement when the regulations cannot be changed. Well, when regulations cannot be changed, you don't need vested rights. So the vesting section was intended to apply during the period of time, which again, in this case was 6 or 7 months, but could have gone on for years, for the period of time between expiration of the build-out period and termination of the development agreement. And that's where 3.23.2 says the development standard shall continue to apply during that period of time that we've just been talking about. So vested rights, the vested rights created by 3.23, once created, frankly, are not only contract rights, they're not only statutory rights, they're also constitutional rights, as a number of cases, including the West Main case, have made abundantly clear. And the city, the director in its briefing, has no response to the West Main case. It doesn't exist as far as the director's briefing is concerned. Constitutional rights, once created, yes, they can be waived, but the waiver has to be intentional, it has to be knowing, it has to be clearly expressed. Usually the cases say there has to be an affirmative act to waive a constitutional right. There is no affirmative act here. There is no intentional, clear, no waiver of any sort, because the right that was created according to this contract is a vested right, which by definition is a right that continues after the regulations change. It is beyond belief to think that a sophisticated developer investing hundreds of millions of dollars to develop hundreds of acres of land would knowingly create an anti-vesting provision and intentionally waive the vested rights that it was creating in this agreement. To say that vested rights were created, as they clearly were in 3.2, but those vested rights are illusory because as soon as they mattered, they would go away, is frankly the absurdity of the city's position. And there is no way to avoid the absurdity of that position. it makes absolutely no sense. In the real world, it makes absolutely no sense in terms of the case law or of the statute. Now, again, Mr. Examiner, you referred to this gray period, and
Right.
I understand why you use the term, but I'm going to respectfully disagree that it was a
Certainly.
gray period. It is the period that is expressly dealt with by the language of the development agreement, the contract that is at issue here. And that is the period of time in which the development standards shall continue to apply. So having created that vesting right, there is absolutely no waiver anywhere of that vesting right. And again, the word thereafter, has to be given meaning. It says thereafter, referring to the period when the replacement regulations are adopted. Thereafter, the new regulations apply. Well, the city, again, asks you to interpret thereafter in what I'm going to call an oxymoronic way. They're saying, well, thereafter means it also applies to the period before that, because that's the period of time when we created these anti-vesting provisions, this non-permanent vesting provision. So thereafter, in this case, really means before that, going back to the expiration of the build-out period. Again, given a term, a clear term with a universally accepted meaning, the exact opposite meaning of what everyone else in the world gives that term is not consistent with any canon of contract construction.
Okay, I think I understand the argument.
So I'm going to, there's a lot more we can talk about. I'm going to wrap up in part because you just said you understand the argument. But I'm going to come in, I'm going to ask you to look at the case that we cite on page 7 of our response to the city's motion. It's the Bailey versus school district case. And it's a Washington State Supreme Court case, an old one dating from almost 100 years ago, citing an even older U.S. Supreme Court case. It says, a vested right of action is property in the same sense in which tangible things are property and is equally protected against arbitrary interference. Whether it springs from contract or principles of the common law, it is not competent for the legislature to take it away. The legislature, in this case the city council, could not divest shelter, and the director, acting on behalf of the city, cannot divest shelter. And the clear language of this contract, of this development agreement, and we interpreted it in our motion as much, at least as much, if not more, as a contract than as a regulation. It creates those vested rights, and it's not competent for the city to take them away. And finally, again, going back to the context rule, and why no developer in his or her right mind would have agreed to a contract of the sort that the city is asking you to create here. One of the things you can vest to under this contract is mitigation. We're talking, again, about an incredible investment in the highway that gets you up to the highlands, into the stormwater infrastructure, into the streets. There was more at stake here because that mitigation was part of what you could vest to. SEPA was done up front. Everything was done up front so that a developer who could come in and submit an application, know they would get quickly processed, they would get a permit, and they could get on with it because the investment was made up front and it was paid for up front. By denying vested rights, you're not just taking away, the city is not just, the director is not just taking away the right to proceed, it's taking away all the mitigation that went with the development agreement that is, that is part of the vested rights in this case. The development agreement draws absolutely no distinction between applications that would vest under state law and applications that would vest under this development agreement. In the same sentence, it defines implementing approvals to include, plats, building permits, and then it goes on to other things that are specific to this development agreement, including the site development permits. It draws no distinction, it includes them together, and nowhere else in any of this language that the city is asking you to interpret is any distinction drawn.
Well, arguably, the development agreement is more explicit than state law. I mean, depending on how you read Patala Village, or a case that I was hoping someone would bring up or talk about or cite, which is an Alliance Investment Group versus Ellensburg out of Division 3. That was 189 Winnap 763 from October of 2015, because it has a detailed explanation of at least Division 3's view on how vesting now works, and Division 3 is very much of the opinion that, I don't want to say Potala Village overruled the Washington State Supreme Court and its previous decisions, but of the opinion that really the only things that vest anymore are preliminary plats and building permits. So the development agreement and the section you're citing would seem to, depending on, again, on how you interpret that case law, provide, a greater protection in terms of vesting, if I agree with your argument.
Well, yeah, it clearly was, even disregarding that case, which, again, no vesting case has been overruled. And this kind of, discussion, which is dicta by some courts of appeal, doesn't overrule anything. It doesn't undefine vesting, and consistent with the state statute that authorizes development agreements, consistent with the Erickson versus McLaren case, consistent with the parties to enter into agreements. I mean, we agree, the only thing we agree upon, I think, with the city is that this is a contract and it should be interpreted according to contract principles. But all of those principles, when applied in light of the facts and circumstances, the conduct of the parties, the plain language of the contract, demonstrates that vested rights were created, that they were incredibly important to the applicant in 1996, just like they're incredibly important to my client, because there is so much at stake in these applications that isn't in stake at others, where people haven't done the mitigation yet, they haven't done the SEPA, they're just starting the process. Applications in this case were submitted after years of effort and environmental review and mitigation. So the vested rights are keenly important in this case, and they were agreed to.
I am having trouble fully grasping, and maybe that's a material factual issue that I don't fully get, but the appellant has argued several times in the briefing that if these permits are not treated as vested, they lose the rights to the mitigation that has occurred. But why is that the case under SEPA? If an applicant has already performed an EIS, I don't know what happened here, I'm just, on theoretical basis, an EIS for a particular property and mitigation has already been paid for a particular property, why does it matter what sort of zoning regulations are in place? I don't understand why by losing vesting status, all of a sudden you're going to have to do additional mitigation or even additional SEPA review. That's just...
I'm happy to respond at length to that. I think I have to go outside the record before you to do so.
Oh, let's not go outside the record then. let me remain confused at the moment and decide what I want to ultimately do with that. I mean, from a theoretical standpoint, do you have a response to that? I mean, if,
Well, speaking in the abstract.
in the abstract,
If you have to go, SEPA was done under this development agreement, both procedurally and substantively. The EIS
a
was.
distinction I always have a problem hearing, but go ahead.
Okay, but SEPA was completely compliant.
All right,
The
SEPA happened.
The EIS was done, the mitigation was agreed upon, the mitigation was done.
Okay,
So if we're not vested, leaving aside all the others issues in this case, then the applicant has to come in and go through SEPA again. It has to.
why? That, I don't understand that, Mr. Schneider. If SEPA was done and an EIS was prepared for a particular parcel, right? This is a physical piece of land. I don't understand why vesting matters at all.
And again,
Is this outside the record? That's, okay.
I have a very strong response to that is outside the record, that is based on the current conduct of the city. But leaving that aside, the EIS in this case is old. And if the vested rights go away, then the city can easily take the position that you have to do SEPA again because the EIS is no longer an accurate.
Okay, so even in the abstract, I can understand the concern of, even if an EIS were done, because it was done so long ago, a SEPA responsible official might take the view that updates are necessary, and such updates are time-consuming and expensive, et cetera,
Well, that's the process side of it.
Okay.
There's also the substantive side of it. They can come in and make an entirely new, unencumbered decision, unencumbered by.
Again, in the abstract.
In the abstract.
Yes, okay.
And impose additional substantive mitigation.
There, okay, that argument I better understand.
And I can tell you, without, going beyond this record, that sort of thing is happening right now in the city of Seattle. Where you've got there's an old downtown heightened density EIS that multiple developers adopted for permitting their downtown projects. Well,
Familiar
that
with
is
the
now
issue.
long in the tooth. The city is no longer doing that, and they're starting over again, even though there's a good argument that everything is still within the scope of that. There's been a policy change.
Got it.
And just to give you the site to the fact that mitigations are at issue here, it's page 30 of the development agreement. It's the definition of development standards, which expressly include mitigation measures.
Page 30. Sorry, I know there's a section, even in the vesting section, it talks about vesting of mitigation, but what was that site just to?
This was to the definition of development standards, which.
Oh, I think for me, that's 29, but that's okay. Got it. Okay, well, thank you, I think.
And just for clarification in the record, since we do have different page numbers, the copy of the development agreement that we submitted with our briefing is the original development agreement. So
Okay.
there's no red line changes to it.
Got it.
Whereas the version submitted by the city has some words crossed out in red line. So that might, I don't know, but.
I
that
think
might
that's
be-
probably the difference. I think mostly all they did was cross out Grand Ridge and put in Highlands, but
Yep.
I don't think there's any substantive changes.
Not in the
is-
language we're dealing with.
Yeah, I mean, if one of them signed, I guess that would be the better, most official document to use. Is
And
that-
that's the original that we submitted.
you have submitted,
Yeah.
okay.
My understanding is and Zach can correct me if I'm misstating anything, but is that the red lines are posted on the city's website and they were supposed to reflect some other changes, but they're not formally adopted changes that were
Okay.
signed by both parties or all three parties.
Sure, but I guess anything I would probably cite to wouldn't be by page number, it'd be by section, so hopefully that will clear up any misunderstandings, and I think the parties can agree there's no substantive differences between the two documents, is that accurate?
Not in the three sections that are primarily at issue here.
Okay, great. Okay, Ms. Schneider, did that conclude? I didn't mean to cut you off.
If I could read one more note.
All right, one more note.
Yeah, I just want to emphasize that the development agreement statute, says the parties shall address vesting.
Sorry, the development agreement statute,
Yeah.
are we talking under the
36
RCW or?
Yeah.
Okay,
The statute.
3670, okay.
Yeah, 3670,
Got it.
170, or 180.
Yep, just making sure I knew what you were talking about.
Yeah. It says this contract should address vesting. So absolutely, it depends then on the terms of the contract and how you interpret contracts. But, subsequent case, this contract was entered into in 1996. The case law that you've asked about, the Patala Village, the Division III case, they can't undo that, those contractual rights. And that were entered into and have to be interpreted in light of the law as it existed in 1996.
Well, that was, I guess, my opening question when you started, and maybe I wasn't clear, but the idea being everyone knew what vested rights were in 1996. Maybe 2-3 years ago, you're very confident, but maybe some development directors, some hearing examiners are less confident on what vested rights mean. But is your argument that really that doesn't matter to the extent that the rights at issue here were agreed to essentially by the parties, and that's what matters for purposes of contractual interpretation?
I wish I'd said it that clearly, yes.
Okay.
That is my point.
Great. Did you have anything further on your?
I hope I get a short reply.
Okay, well then at this point, I would like to turn it over to Mr. Lell. Thank you, Mr. Lell. If you can just introduce yourself for the audio.
Thank you. Good morning, Mr. Examiner. Zach Lell on behalf of the City of Issaquah Development Services Department.
Perfect. Please proceed.
Thank you. I think the overriding concern of the city and hopefully of the examiner in construing this dispute and reviewing the parties' respective positions is to discern the intent of the parties to this development agreement, because this development agreement is by definition a contract, and the most fundamental, basic, and important rule of interpretation in this context is to figure out, and to the extent reasonably practicable, effectuate that intent. And as the case law is clear, where the language of a contract is clear on its face, there is no need to resort to other additional, more subordinate rules of interpretation. And it is the city's position that with respect to implementing approvals defined under the development agreement in the way that Mr. Schneider referred to the extent that those are submitted after the development agreement's build-out period has expired, this contract is crystal clear as to what happens to them and what their vested or non-vested status is. And it's kind of remarkable that after 10 months of public hearings and probably 50-plus hours of testimony and literally hundreds of documents that are now exhibits in the record, what we are left with is essentially 3 provisions of this development agreement that bear primarily on this issue of intent. And those 3 provisions are section 3.23, 3.23.2, and 5.13. And specifically the latter of those 2, as they relate and specifically govern what occurs after the build-out period. They begin with the language that Mr. Schneider has recited to you in section 2.3.2 after build-out, and they proceed to state the development standards shall continue to apply to all applications for implementing approvals submitted after the expiration of the build-out period. That is the general rule that is announced by that subsection of the agreement. And if that statement were the only text in that section of the development agreement, then the city would concur with Mr. Schneider. But That's not what this provision provides for. Immediately following that clause, in the same sentence, there is a significant exception. And an exception, using the word except, is in itself a well-established term of art in the English language, and it, by its terms, by the plain context and by its terms, is intended to qualify and caveat the immediately preceding general rule. So the general rule is that the development standards of the agreement would continue to apply to implementing approvals. Here, the ASDPs and SDPs submitted by Shelter after the build-out period expired. But then the same provision of the contract proceeds to clarify that either party can terminate the agreement, and the zoning and development regulations may be modified as provided in section 5.13. And if you go to section 5.13, the cross-cited section, there's a lengthy discussion of the city's termination process that culminates in the last sentence of that provision, and referring to the replacement regulations that everyone anticipated the Issaquah City Council would adopt to replace the development standards that are set forth in the agreement. And that last sentence of section 513 is dispositive for this appeal. It states, upon such adoption, this agreement shall terminate, and thereafter the UGA portion of the property shall be governed by the adopted city zoning and related development regulations. So expressed and summarized linearly, what those provisions collectively state is that applications submitted after the build-out period will continue to be governed by the development agreement standards until the city adopts new zoning regulations for the Issaquah Highlands, which the City Council did through the adoption of ordinance number 2830 on March 19 of 2018. The agreement clarifies unequivocally the effect of that adoption process. As soon as those regulations are on the books, as soon as they have been adopted, the development agreement terminates and those regulations control, they govern.
And that's even if I, the developer, submit an application, so I'm after the expiration, if you will, of the build-out period, but prior to termination.
Yes.
Even if I submit an application the city deems complete, the next day, the new ordinance is adopted, then I have no vested rights.
That is the plain language of the agreement. I
Okay,
don't
just
think-
want to be clear on what your argument is.
And to be clear, this goes to a larger issue, but the rights in question there cannot be credibly deemed vested in the first instance, and I think that's the most fundamental point of dispute between the city and the applicant in this case. The applicant's legal argument essentially assumes its own conclusion by repeating over and over again the mantra that they are vested, that their permit applications, their ASTP and STP applications that were submitted after the build-out period expired are vested, and that the city cannot take those vested rights away from them. And that's simply a misnomer. It's a mischaracterization of whatever rights they would have had under the agreement. And here, going back to the issue of intent, I think it's critical to note that the framework that I just described that is set forth in those two provisions of the development agreement is completely on its face irreconcilable, fundamentally different from any concept of vested rights. Because vested rights, as Mr. Schneider had indicated, can't be undone. If you have a vested right, except in very narrow circumstances, they can't be taken away. But this contract doesn't create those sort of vested rights in the first instance for SDP and ASDP applications, which, like shelters, were filed after the build-out period. There's no vested right to take away because no vested right exists there. They're essentially living on borrowed time, and submitting those applications after the build-out period expired assumes the risk that the city will in fact adopt new regulations which, by the terms of this contract, will govern immediately upon their enactment. On the issue of intent, And going back to Shelter's reference to the context rule, which I largely agree with, although the city fundamentally disagrees with how the applicant has framed that issue, I think it's also critical to note that not only is this development agreement a contract where the parties have contractually, mutually negotiated and defined their relationship, but also their vesting relationship, that this development agreement was executed under the auspices of Chapter 3670B RCW, which is the only Washington statute that authorizes and endorses and defines the parameters for development agreements. And there are 3 provisions in the statute that I think are, if not outright dispositive, that should at least significantly inform the examiner's review of this appeal. The first is in section 3670B 170 subsection 1, and it provides in relevant part in the 3rd sentence, a development agreement must set forth the development standards and other provisions that shall apply to and govern and vest the development, use, and mitigation of the development of the real property for the duration specified in the agreement. It doesn't say automatically a permit applicant is vested just because the permit application at issue might have been submitted during the effective term of the agreement. This language of the governing statute is clear. The vesting applies for the duration specified in the agreement. Further down in section 170, in subsection 3I, one of the provisions that a development agreement should contain is a build-out or vesting period for applicable standards. The statute uses those terms, build-out or vesting period, interchangeably. It's the same thing. And again, this dovetails perfectly with the preceding section that I had just quoted, which is that there is some other lesser duration of a development agreement during which vested rights may accrue, and by implication, there must be a different era or duration or period under the agreement under which vested rights do not accrue. And finally, and I think most importantly, RCW 3670B 180, in defining the effect of a recorded development agreement, provides in the second sentence, it provides in the first and second sentences, unless amended or terminated, a development agreement is enforceable during its term by a party to the agreement. A development agreement and the development standards in the agreement govern during the term of the agreement, and this is the critical language, or for all or that part of the build-out period specified in the agreement. That language is exactly the format that was used by the parties to the 1996 Issaquah Highlands Development Agreement at issue in this appeal. It uses the same terminology, i.e. development agreement, development standards, build-out period, and it tracks precisely the type of period-specific, durationally specific vesting option that this governing statute authorizes. And if there's any question, and there shouldn't be, as to what the party's intent was in this regard, separate and apart from the plain language of the agreement vesting provisions themselves, in the preface of the development agreement, this new statute, the statute that ultimately became 3670B RCW, is specifically cited. The parties were relying on the authority provided by this development agreement statute to effectuate their deal. That is precisely the format and the framework that the city and Shelter's predecessor Untitled used to define their contractual obligations under the development agreement here. And that is the appropriate context and the appropriate governing law that should inform the examiner's review of this situation. And looking at that in proper context, and specifically the authority provided by RCW Chapter 3670B, the entire concept of non-permanent vesting or durationally specific vesting or a vesting period. These are not anomalous concepts that the city of Issaquah has somehow manufactured out of whole cloth. These come straight out of the governing statute. The parties to a development agreement can define a build-out or vesting period during which their vesting opportunities exist, but after which they don't. If you look at the language of 3.2, 3.2 of the Issaquah Highlands Development Agreement, it follows this to a T. It provides a general rule that applications submitted after the build-out period's expiration will continue to be governed by and presumably processed under the development agreement's auspices, but that protection evaporates. It is eliminated as soon as the city adopts new replacement regulations. And what we've heard from Shelter throughout this dispute, and reiterated it here today, is their belief that a sophisticated party who would have spent all of the money that Shelter alleges was spent back in 1996 to purchase and develop the property in question would never have agreed to this type of a provision. And I would respectfully submit to you that not only does the agreement text itself belie that proposition, but the developer was obtaining something much more important than the standard vested right. The developer here was obtaining, through the contract, a 20-year period, the build-out period, during which the city was contractually prohibited from modifying the development standards that were set forth in the agreement itself. That is an enormously valuable right, and it provides a degree of certainty and stability to any landowner, and particularly the original signatory of this agreement, much more so than the run-of-the-mill development situation where developers have to be concerned that a city council will adopt an emergency ordinance or a moratorium or interim regulation on a moment's notice and essentially deprive that developer of its development intent. That's fundamentally not what happened here. Here, the parties had the stability, the deliberate stability of a 20-year build-out period during which the development agreement standards would control. And there is no argument that the city did not live up to its end of that bargain. The city did not adopt new replacement regulations for the Issaquah Highlands area until March of 2018, almost 22 years after the execution of this agreement. On the issue of intent, which again should be the governing review principle for purposes of this contract dispute, in the city's brief, we've cited and quoted the two statutes in Washington that do provide vesting. And those statutes are very well established. They were adopted in 1987. They were on the books in Washington, essentially unchanged, when the parties to this development agreement negotiated and executed their contract. And those statutes are the preliminary plat vesting statute at RCW 58-17-033 and the building permit application vesting statute at RCW 1927-095. The language of those statutes, the quintessential vested rights language in Washington state, is fundamentally different from the language set forth in this development agreement. The language of both of those statutes, again, they're quoted in the city's brief, states by their terms that an application, a fully complete application for a building permit or a preliminary plat or short plat, will be considered under the land use controls and zoning regulations in effect at the time that a complete application is submitted. There is literally nothing like that. There is no corollary language, no approximate language anywhere in the text of the 1996 development agreement. Again, what the section entitled vesting, section 3.2, provides for is not that sort of language borrowed from RCW 58-17-033 or 1927-095, but instead there is a simple promise made by the city that it will not modify the development standards during the build-out period of the agreement. That's the extent of vesting under the 1996 agreement, And that approach to vesting, that approach to that build-out period, is almost verbatim the same framework that is authorized by RCW 3670B180, again, the governing statute. So it begs the question, if the parties to this development agreement, the original signatories, had wanted to create a permanent vesting framework and to ensure that permit applications like shelters that were submitted after the build-out period of the agreement would continue to be governed by the standards in the agreement and not be subject to new regulations when they were adopted, they could have easily done that. They could have done that in at least two different ways, either of which would have been simple, clear, concise, and direct, and would have obviated this dispute. The first way is the one that I've intimated previously, and that is, and they could have simply cut the first clause out of section 3.2, 3.2 of the development agreement and had that stand alone as its own vesting provision. And had they done that, I don't think we'd be here today, but they didn't do it. Instead, they caveated that general rule with the huge exception, the centerpiece exception that follows it. The second thing the parties could have done if they wanted to provide for vesting protection for post-build-out submittals would have been to use the exact same language from the two RCW provisions for either the plat statute or the building permit statute, or language approximating that. And that would have been sufficient to vest those post-build-out period submittals. But the parties didn't do that. They had certainly the option to do that. Those statutes were available as a template to use for this purpose, but the parties chose not to do that. And that in and of itself, I think, speaks volumes, particularly, as Mr. Schneider indicated, given the sophistication of the parties who negotiated this deal. And the fact that they didn't use language like that, I think, is critical. I'd like to touch briefly on the issue of the standard of review. I've heard from Shelter, both in their briefing and today, that the clearly erroneous standard that is set forth in the city's code should somehow be colored or diluted by other principles that I believe that they are attempting to import from the Land Use Petition Act review standards at RCW 3670C 130. With all respect, those are simply inapplicable here. This is not a LUPA appeal. What happens when and if this gets to Superior Court is obviously another matter. That's going to be up to the judge and will be informed properly by the judicial standards of review that are set forth in LUPA. Here, the governing standard for purposes of this proceeding is the one that is codified at Chapter 1.32 of the city's code. And that unequivocally, categorically imposes a clearly erroneous standard. That standard, in and of itself, is largely dispositive here, because even if Shelter were to come up with a plausible alternative interpretation of the relevant development agreement text, you would have to find not only that that alternative interpretation was plausible, was viable, or even that it was possibly better than the city's, you would have to find that the director's interpretation in issue was clearly erroneous. And because of that, there is appropriate deference built into that standard of review. I'd like to also touch briefly on the prior statements of the director that Shelter has raised to other parties and at various points to Shelter itself. The first and most fundamental response to that is that none of those other writings or responses or communications are properly at issue here. This case, this appeal, deals exclusively with the director's September 17, 2018 staff report, which contains his vesting determination under IMC 1801050C. And the Development Commission's notice of decision, which essentially acknowledges and subsumes the director's vesting determination. Anything else that the director may have said or done is simply irrelevant to these proceedings. I will submit to you that the shifting or changing, or whatever the term that Shelter used, evolution of the director's messaging or thought is not what the appellant here would lead you to believe. The city conceded during the administrative proceedings below that it made a mistake in processing the Polygon or Westridge matter. That's a separate applicant. There was no appeal from that, and
I'm going to object. I strongly disagree with that characterization.
And this is outside the record. I mean, to the extent that I have no idea, that nothing that has been submitted before me says that, I don't think.
Okay, I'll retract.
Did I miss it? Is
It's
it in here
it's-
somewhere? I
to-
mean,
To answer your question, it's in the record. I don't know if it's in these materials.
sorry, the record before me as opposed to
Yes.
the enormous record.
Sure.
And ultimately, I don't know if it's relevant to the extent that I do understand the argument that even if the city, we'll say, screwed up and changed its mind on several occasions, I have actual decision before me that I need to decide, and anything that happened otherwise would only matter if I'm looking beyond the four corners of the document, you know, if I was looking at damages in a totally different kind of forum. You know, I understand that and there's enough material in the record to show both sides, you know.
And that's my point. I'll retract the previous reference
Sure.
for purposes of today's record. Again, the salient point from the city's perspective for purposes of this motion is that you have a very clear vesting determination in front of you, and that is the only one that is properly before you in this proceeding. And if we're agreed on that, I don't think there's any need to elaborate further on that point. A centerpiece of Shelter's appeal argument is their attempt to graft onto the framework of this development agreement an entire body of common law vested rights that have no place in this specific context. The body of state law that should inform, or that did inform, and that should govern this development agreement is the authorizing statute, the governing statute for development agreements. That's the state law that's specifically called out in the agreement itself. That's the state law that essentially mirrors the terminology and framework of this development agreement. Trying to selectively subject common law vesting principles into this document, I think, is an exercise that doesn't have any roots in the law properly. And the basis for Shelter's attempt to do that is largely distilled into one word in the section heading for section 3.23 of the agreement, which uses the word vesting. I believe it's the only reference to that term in the entire document. It's not a defined term in the agreement, but I would respectfully suggest that the substance, the actual content of that section, the text that follows that section heading, should be dispositive and should be the focus of your analysis, not an isolated word in the section heading itself. Because there are various terms that are defined, most importantly the build-out period, defined both in the agreement itself and by reference to the governing statute, that are, I believe, much more relevant and bear much more directly on the outcome here. I think you had touched on the issue of the Alliance Investment Group case. The city is very aware of that case. I don't think that that is as germane to this particular proceeding. As the examiner is aware, the city has moved for partial summary judgment only. There are 2 or perhaps 3 issues that the city frankly just ran out of room for. I think that they are definitely amenable to summary disposition, but given the 15-page limit imposed by the examiner, we did not feel that
It's my fault.
Well, it's collectively the group, and I think that there was significant testimony on those issues, and I think that in order to address them in an accurate, thorough manner, I do believe those should be subject to their own briefing or motion schedule. And that's the reason that the city did not bring up the Noble Manor line of cases, specifically including the Alliance investment case. That frankly bears more directly on the vested status and the extent of vesting that Shelter's preliminary plat application may enjoy, and it is not as relevant to the issues before you in this motion for summary judgment or partial summary judgment. The same issue applies to their Mainview versus Bellevue argument. There's also a lot of testimony and evidence in the record regarding that. We believe that it is amenable for summary disposition, but again, space constraints prevented us from doing that here. In conclusion, Mr. Schneider made a point, and I'm paraphrasing here, in his opening comments that I think resonated with me, and that is essentially that the parties can agree on vesting in this context. And the city agrees with that, and we concur in that position. I think we have wildly different beliefs as to what that means and what the outcome of that principle should be as applied in the specific context here. But that's the entire point of the city's argument in its summary judgment motion. Not only that the parties can agree on vesting, but that the parties did agree on vesting. They agreed on it under the framework established by the governing statute, Chapter 3670B, and the effectuation, the manifestation of their agreement on this point related to the vested status, if any, of applications that were submitted after the build-out period is very clearly set forth in Section 3.23.2 and Section 5.13. That is the deal that the parties made, and that has been a recorded constraint on title for this property since 1996. Everyone should have known, did know or should have known, what would happen after the 20-year build-out period of this agreement finally expired. And at the end of the day, Shelter is left with that inescapable fact. There was a 20-year period to come in and develop their property, and they didn't do it during that time. So by submitting applications after that build-out period, those applications are, under the plain language of the agreement, going to be vulnerable to and ultimately subject to any new replacement regulations that are adopted by the city. That again is the plain text of the development agreement provisions that have been cited to you, and I would respectfully suggest that even if differing interpretations are possible on that language, that the applicant has not and cannot demonstrate that the director's interpretation of those clauses was clearly erroneous. And for that reason, I would respectfully ask that the examiner grant the city's motion for a partial summary judgment, schedule a new briefing or motion schedule to address the remaining issues of the appellant's notice of appeal, and to deny the motion for summary judgment that was submitted by Shelter.
Thank you, Mr. Lowe. Mr. Schneider, you have a response?
Yes.
Thought you might.
You've been presented with two dramatically valuable views of the world. Obviously, you will decide who's more fairly and reasonably representing the language in the development agreement, but I want to respond to a few specific things. And I want to begin by talking about a document that the city itself submitted about this issue, that how clear it is that, I heard some remarkable language about how clear and unequivocal it is that the applicants back in 1996 agreed that there would be no vesting rights after the expiration of the build-out period. The city's motion for summary judgment has some appendices to it, and I think it's the second exhibit in those appendices, maybe the third. But it's the November 16, 2017 staff report about, it's called Ray End of Development Agreements Application Vesting.
C6.
Yes, C6 from the commission hearing below. If you turn to the second page of that, well, first of all, if you look at recommendation 2 on the first page, it's basically recommending that the replacement regulations allow applicants to vest when they submit an application for an SDP and an ASDP. Basically a recommendation that the replacement regulations provide the same kind of vesting that we are saying that was agreed to in the development agreement. If you turn the page and look at the third paragraph from the bottom, it says, it is the administration's support, the syntax is garbled, but it is the administration supports alternative 2 as it is consistent with the vested rights doctrine and the decision of West Main versus Bellevue. Since the administration requires a land use permit to be issued prior to the submittal of a building permit, a complete land use permit has been viewed by the administration and city attorney as part of the building permit process. The city itself has presented evidence in front of you that it has a West Main problem if it does not allow an applicant to vest when they submit an application for a site development permit. So the argument the city is making to you today is not only inconsistent with the development agreement and all of the law, its vested rights, it's inconsistent with the city's own position that it had to allow applicants to vest when they applied for a site development permit because West Main compelled it. So they are basically asking you to make a decision that is inconsistent with West Main, a case they declined to address in any fashion in the 3 briefs they have submitted in this case. And I encourage you to read that document with care.
Thank you. Did that conclude your remarks, Mr. Schneider?
They can, but I have a lot more.
No,
to
no,
say.
well, you paused, you were letting me read, so
Letting you read.
go ahead.
So I want to respond to your comment about, you're looking at the 4 corners of the September vesting interpretation. Obviously, that is the interpretation that is in front of you, but the development agreement has to be interpreted according to the context rule. And the context rule includes, as I quoted in that footnote, the prior actions and statements of the parties. And that is what makes not only the exhibit that I just presented to you, but the director's communications with Polygon and with us saying that you are vested relevant to your interpretation.
Is the context rule always applicable for every contract, even if I don't think there's ambiguity?
My understanding
It's
of
been
the
a
way...
while since I've thought about this.
My understanding of the way the Supreme Court has settled all of this is that you do look at, it's not just a question of plain language, because in interpreting the plain language, you have to look at the entire agreement and the context. And I think it's the Campbell v. Gwynn case, which I don't think anyone cited in this case, but it's the Supreme Court case where I think they most clearly articulate that. So I think the context rule is important. From my point of view, there is no ambiguity in this document whatsoever, because it clearly was using the term vesting in the way everyone understood it to mean at the time, at least everyone outside the city of Issaquah. But even then, I submit the city of Issaquah and its attorneys agreed that vesting meant what all the case law says it meant. And but again, I think you are supposed to look at the context even when there is language. But again, the plain language of this agreement is, I think, and I agree with you, it's unambiguous. And it can only lead to one conclusion if words are given their common meaning. Again, the city continues to, Mr. Lell in his comments continues to refer to non-permanent vesting, an oxymoronic, non-existent concept. He asks you to interpret the word thereafter to mean prior to that point in time, not just after that point in time. And he asks you to accept, just as a matter of course, that the parties were, by the language they chose to use, agreeing that an applicant could not vest, and it was simply up to the city as to when and how they would process an application that was submitted after expiration of the build-out period. Again, I submit it doesn't withstand, it's not consistent with reason. Mr. Lell says, well, if the parties had wanted to write this agreement the way Shelter is asking to be interpreted, they could have changed a couple of things. Well, the way the city is asking you to interpret this agreement is as if it never existed, as if there were no vesting provision in the development agreement, so that the parties said there was going to be a build-out period of 20 years. At the end of the build-out period, the city council can take as long as it wants to enact placement regulations, but because there is no vesting under the development agreement, the only vesting that would be in place during that period would be plat and building permit applications. So that's basically what the city is saying, that after the expiration of the build-out period, you could only vest by submitting a plat application or a building permit.
I maybe understood Mr. Lell differently. I suppose the way I understood Mr. Lell was under section 323, in that period after expiration of the build-out period, you would still theoretically vest to the terms of the development agreement so long as the city council had not adopted new regulations.
No, I respectfully disagree. I think he's saying that you can apply to those regulations, but and here we get into a question where I think he's saying two inconsistent things, but the outcome is the same. He's at some point in time in his briefing, he's saying you don't vest. Again, there's even a footnote that clearly says you don't vest even during the period of the build-out agreement. But he's both saying you don't vest, and then he's saying, well, you vest, but the vesting goes away, which is not vesting. So those are tantamount to the same thing.
Okay.
So I think what he's saying, and he can, I have no problem with him correcting me when I'm done here if I'm misspeaking. I think what he's saying is that you can apply, and if the city, gets around to issuing your permit, then great. But if it doesn't, then you're subject to whatever regulations are adopted regardless.
Right. I think that's different than what you just said. What you just stated is what my understanding of Mr. Lell's argument was, not what you said just before that. I'm now a little confused, but I also won't rely on you to make Mr. Lell's argument for him. I'll rely on Mr. Lell.
Well, and I apologize because
No, it's
in
okay.
my mind, what I said was consistent. So
what if we use the word govern in this instance instead of vest? So my question for you is, what governs what in the appellant believes that the development regulation should govern so long as a complete permit has been submitted and accepted by the department, whereas the city's view is, what rules will govern actually depends ultimately on well, hold on, now I'm confusing myself.
if I could take a crack at it.
Yeah, go ahead.
I think what the city is, regardless of what I believe are contradictory ways as to how the city is saying it, I think the city is saying after the expiration of the build-out period, your application is governed by whatever regulations are in effect at the time they make a decision.
Yeah, okay.
And we're saying no, the regulations that apply are the ones that were in effect at the time we submit a complete application.
There, okay. I think that is the fundamental difference of opinion there.
So if the regulations that apply are the ones that are in effect at the time the city makes a decision, that of course gives unbridled discretion to the city to delay ruling on applications, and it also means there are no vested rights.
Right, we'd be in the majority of states in this country that don't have vested rights.
Exactly. And so, again, Mr. Lell then says, well, of course, it's clear that that's what the parties intended. And I think that is so profoundly inconsistent with the language we're talking about that I'm sort of speechless in response to that. But again, if that were the parties' intent, they wouldn't have a vesting section. They could have just, basically said nothing, and it would have been up to the city to be completely in control of the situation.
Weren't they required to have something about vesting by the explicit terms of RCW 3670?
Yes, but they could have said no vesting, because that's
Okay.
the effect of what Mr. Lell is arguing for here. So, yeah, rather than have nothing, they would have said there are no vested rights under this development agreement. That's what the city is asking you to believe the parties agreed to. Now, the state statute, is the enabling statute. It doesn't say what the parties agreed to in this case, and it does not equate the build-out period with the vesting period any more than the agreement does. It uses the word "or." So those things are alternatives, or can be alternatives. It's up to the parties as to whatever they agree to. And here the parties agreed that there would be 20 years when the regulations couldn't change, and therefore vesting didn't matter, and then there would be a period after the regulations couldn't change before the new regulations were adopted. There could be an indefinite length of time, and that is the vesting period, because that's the only period when it mattered. And I think it's clear that was the party's intent. And again, Mr. Lell is asking you to accept a position that is fundamentally inconsistent with what the city said and did, not only vis-a-vis shelter, but vis-a-vis Polygon, before the regulations changed. The November 22nd email exchange, the March 2017 letter to Polygon, the March 2018 agreement with us, they're all inconsistent with the arguments the city is making today. They are, however, all consistent with the plain language of the development agreement and with state law. So I think I don't know that I've ever seen a more starkly contrasted view of the world presented to a decision maker than in this case. But
I see it all the time.
Well,
But your point there speaks to the importance of the context rule.
well, and to the plain language.
Okay.
I mean, either the word thereafter means thereafter, or it means the opposite. Either the word vesting means vesting, or it means non-permanent vesting, which is not vesting. Again, at bottom, I think I'm simply asking you to give words their common meaning. That's such a fundamental concept that, is certainly supported by every vesting case we cited. And we argued this case as a contract case, at least as much as we did a statutory interpretation case. Thank you.
Thank you, Mr. Schneider. Mr. Lell, can you speak quickly to make sure I understand the city? We didn't want either myself or Mr. Schneider to mischaracterize the city's view on Section 323.
Sure, and going back to your interplay with Mr. Schneider to make sure that I am addressing the right question. The city's point, and this is, I believe, set forth in the city's brief, and it's subsumed in the director's staff report, that establishes the vesting determination at issue before you is that applications for permits, for site development permits that are submitted after the agreement's build-out period are not vested in the first instance. And those permit applications would essentially have the same status and the same vulnerabilities and would implicate the same risks as any non-vested permit application under state law. And it is not an untoward or uncommon or novel outcome in the city's view. There are only two categories of permit applications that vest in Washington: preliminary plats and building permit applications, and both of those are by statute. So for every other type of application out there in the ether of Washington land use law, if an application is submitted, here a site development permit application, but it could be anything else, it is necessarily going to be governed, or the regulations that will apply to that application are the ones on the books unless and until the jurisdiction at issue adopts new regulations. And if that permit application is still in process during that interim period, then the applicant is going to need to comply with the newly adopted regulations if an actual permit decision has not been issued by the time those new regulations take effect. That is the essential difference between a vested permit application and a non-vested one. And in the city's view, and I agree with Mr. Schneider, this is a fundamentally different view than the one that Shelter is asking you to accept. In the city's view, section 3.2 of the development agreement, its purpose is to clarify that there is no permanent vesting, that those types of permit applications that come in after the expiration of the build-out period are not going to be vested to the standards in the agreement. That is what the exception in that section of the agreement emphasizes. That's the city's point. And then I'd like to touch briefly, if I could, on the West Main argument. Again, the city did not address that in its briefing because we aren't moving for summary judgment on that point here. It's not that the city is conceding that point in any respect. We have not provided argument or evidence on that issue because it is beyond the scope of the city's summary judgment motion and the one submitted by the applicant.
Okay, so I think in some respects we've covered the bulk of what the city would be proposing in its motion for partial summary judgment, but I want to quickly hear where everybody's at. Can this be done quickly? How much argumentation on the city's partial motion for summary judgment is needed? Should we take a break first?
I'm happy to proceed right now in the interest of time. I don't know that I have a lot extra to cover. If the examiner could give me a few minutes, I don't think that we need to belabor these points because it's
I think if Mr. Schneider, if your team is okay with that, I feel like the arguments being made in the city's partial motion for summary judgment are very comparable to the arguments that it raised in its response to your motion for summary judgment. Again, we've got fundamentally opposed views of the world at the moment, and that's what's causing the clash. So any issue, do you guys need a break, or do you think we can power through and just get it done?
Assuming it doesn't go on too long.
Okay, well, at any time, feel free to request a quick break, but at this point then, I'll turn it to Mr. Lell to make the argument on the city's motion for partial summary judgment.
Thank you. The bulk of the city's motion for partial summary judgment essentially addresses the same textual arguments, which I believe are the core of this appeal, and it's the proper interpretation of sections 3.23, 3.23.2, and section 5.13 of the development agreement itself. And our arguments in support of the city's motion are essentially part and parcel of the city's arguments in opposition to the appellant's motion. So I won't, unless there's a specific question in the city's theory, I think it's been thoroughly briefed and addressed in oral argument today. I won't belabor those points unless you have specific concerns or questions.
No, I don't need you to belabor the point, so thank you.
The other issues that the city has requested partial summary judgment on are, first of all, the constitutionally based claims that were raised in the appellant's notice of appeal. It is the city's position that those are categorically beyond the subject matter of the hearing examiner. In fact, they're categorically beyond the subject matter of any municipal tribunal under the plain holding of the Exendine and Chaussee cases cited in the city's brief.
1,000 cases, yeah.
Yeah, I mean, I don't think that that's a particularly novel point. You saw from the response provided by Shelter that they are attempting to draw a distinction between the constitutional references in their own notice of appeal and the constitutional arguments that were raised, for example, in the Exendine case. I think that's a distinction without a difference, and I don't know that. Hopefully, we need to belabor that too much, because the case law is so crystal clear that hearing examiners cannot and do not have the power to adjudicate constitutional arguments. That's the first point, and there are a few, as you saw, notice of appeal claims that bear on that, and we would ask that those be summarily dismissed simply on subject matter jurisdictional grounds. The other main point that wasn't covered in our previous oral argument today had to do with the Shelter's argument concerning RCW 3670B and the provision of the city's replacement regulations that governs vesting, IMC 1819B 280. And I don't think that we need to talk too much more about the RCW provisions. We've discussed those at length today. What the city is essentially arguing in its brief and in seeking partial summary judgment is essentially what it's already conveyed to the examiner. The plain language of the RCW, the three sections that we have cited, very clearly establishes and authorizes the type of period-specific vesting framework or build-out period that the Issaquah Highlands Development Agreement mirrored for purposes of this appeal. And that includes the post-build-out period issue, and I think that they go hand in hand. If the development agreement under the authority of the governing statute establishes a build-out or vesting period that is something less than the full term of the agreement, by implication, there must be another part of the agreement, some other era covered by the agreement, under which the parties would not vest, would enjoy the sort of statutory sanction for vesting that would otherwise potentially apply depending on the parties' deal. Again, we've talked about that extensively today. I don't believe that the appellant has provided any contrary argument that would suffice to overcome the plain language of the statute itself, and the city would rest on that point. With respect to the vesting clause of the city's replacement regulations, it's very clear that that provision, IMC 1819B280, simply provides that the city will recognize vesting that is recognized by state law. So the three categories of vesting are preliminary plats, building permit applications, and development agreements. And if I understand Shelter's contrary argument, they are contending that the city council intended that the Issaquah Highlands Development Agreement was viewed by the city council as essentially vesting their ASDPs and SDP applications. And there's nothing in the record that supports that. In fact, the materials that were cited in the city's appendices into its motion clarify that the council was very aware of the effect of adopting or incorporating state law vesting principles. It was that these SDP applications, these ASDP applications, would not be deemed vested. And there's nothing in the record that indicates any contrary intent by the City Council. And as the examiner is aware, site development permit applications do not vest under state law in the first instance. So to the extent that there would be any vesting protection whatsoever afforded to land use applications of this type, it must come from the agreement itself, and the agreement expressly disclaims vesting in this context. So we would respectfully ask that the city dismiss those claims of the applicant as well. We touched earlier on the state law or common law vested rights arguments in our original discussion and argument concerning the appellant's summary judgment motion. I think those are equally applicable here. There's nothing in the 1996 development agreement that purports to incorporate common law vesting. To the extent that Shelter is relying on a single word in the section heading for section 3.23, the agreement itself disclaims any binding substantive effect of section headings, and there's nothing in the document itself that would purport to inject those sort of common law vesting principles into the document in a manner that would be inconsistent with the plain language of the agreement. That's essentially it. I don't believe that there's a need to further argue, given how extensively these issues have been briefed, but I'm happy to answer any questions that you might have.
Well, the simplest thing I could have you do for me at this time, Mr. Lell, is do you happen to have the appeal in front of you?
Yes.
So if you turn to page 6 of the appeal, these are all the reasons the appellant feels that error has occurred, I guess. What of these would remain if I were to grant your motion for summary judgment?
So,
what would we still need to hear about?
So as we've discussed, just kind of taking those in reverse order.
Okay.
The first few are dealing specifically, these are the bullet points that are sequentially ordered on pages 6 and 7 of their appeal.
Yes.
The textual-based arguments are the same ones that Shelter has moved for summary judgment on.
Right.
And we have moved for essentially a cross motion.
Yeah.
Seeking your determination regarding the appropriate or correct textual interpretation. Of
Right,
those.
so the first bullet point is
Correct.
contrary to the plain language of 323. The next
Correct.
one is 3232. So those ones, your cross motion, obviously you just have a different interpretation as
Correct.
them. So those need to be addressed by me, no matter what I ultimately decide. Same with the next one, right? That's just a textual.
Yes, and then the third bullet point is the one that I just addressed in my brief oral
Right.
comments. That was the notice of appeal argument dealing both with the language of the governing statute, Chapter 3670B, and the vesting provision of the replacement regulations in Chapter 1819B,
Right.
IMC. That would no longer remain. The fourth bullet point, their allegation that the city's interpretation would lead to an absurd result, that is addressed in the city's brief, but that is essentially a textual argument as well, subsumed in our earlier oral arguments today. Same thing with the next argument, their contention that the director's determination deprives the word vest of its legal meaning. That's essentially their common law vesting contention. That's also addressed by the city's briefing and in today's proceeding. Same with the next argument regarding common law vesting. The next several
constitutional arguments.
Correct.
So your cross motion says throw those out because the hearing examiner lacks the authority
Correct.
to address those.
So from the city standpoint, skipping ahead then, because the next several bullet points of their notice of appeal deal with constitutional issues, it would be the final 3 bullets on page 7 for which the city has not sought summary disposition.
Okay, the final 3. So the director's vesting determinations violate RCW 5817.0-3 and the case law of noble manner because consistent. Okay, so you're saying if I deny the city's, sorry, if I deny the appellant's motion for summary judgment, but were to grant the city's partial motion for partial summary judgment, we would need additional hearing. I don't know if we need testimony, I don't know what we need, but on these final three things?
Yes, just to clarify, I do not believe that new testimony would be appropriate
Okay.
given the closed record context here. I believe that we are appropriately confined to the record. And
Sure.
But
Good point.
I do believe that additional oral
Additional
argument would be
argument,
appropriate.
okay.
And the city's recommendation and request would be another motion schedule, where there would be a specific, page-limited motion practice followed by a hearing on the motions.
Okay, so I was just trying to make sure I understood what the city believes would be left if I side with the city and grant its motion for partial summary judgment. These three matters, in the
Correct.
city's view, would still need to be addressed.
Yes.
Got it. Thank you. That helped clarify for me, just so I, am clear on what the city feels it's attempting in its cross motion for summary judgment. Did you have further argument then, Mr. Lell?
Not unless the examiner has questions. I think these issues have been thoroughly briefed.
I think they have. Okay, well then I turn it over to Mr. Schneider for any response.
So, Mr. Examiner, just briefly on the textual arguments, I think it's important to note that Mr. Lell continues to use terms in a way that no one else uses them. He specifically referred to period-specific vesting. There is no such concept. Again, this gets back to the city's position that the regulations that apply to applications submitted after the expiration of the build-out period are reviewed under the regulations in effect the time the city makes a decision. That is non-vesting. That is not period-specific vesting. The term permanent vesting does not exist. Vesting either is or it isn't. So the city is basically asking you to use terms that exist nowhere else except in the context of this dispute, and to adopt them as concepts that people had in their heads in 1996 when they entered into the development agreement. That simply is not how you conduct statutory interpretation. On the constitutional claims, again, the cases that Mr. Lell cites, they're cases we're all familiar with, are not at issue here. They're not disputed. I'm not asking you to make a decision about something that is outside your jurisdiction. Each of those cases dealt with something that was clearly outside the hearing examiner's jurisdiction. You have before you the question of the director's vesting determination, which is within your jurisdiction. And this is no different than the principle that Justice Brennan on the U.S. Supreme Court announced back in the 1960s. We expect a cop on the street to behave constitutionally. Why not planners? Well, certainly, an educated and experienced hearing examiner who knows the law needs to act in a constitutional manner, and that's all we're requesting here.
Sure, and I appreciate the flattery, but again, you're not asking that I specifically address impairments that violate due process rights protected by the 5th and 14th Amendment. You're simply asking that I produce a decision that in and of itself is not violative of the Constitution?
Yes.
Okay, so that does eliminate several of the bullet points arguably in the appeal.
I don't agree that it eliminates them. I think we are asking you to make a constitutional decision, and certainly impairing contractual rights, vested contract rights, is an unconstitutional decision. So, we may be watching angels dance on the head of a pin here, but nonetheless, I think it is a valid distinction, and I'm certainly not agreeing that those bullet points are not relevant to your interpretation of the text of the language.
And you're certainly not conceding that you would have abandoned those points for purposes of further review down the line, obviously?
Yes, yes.
Okay.
And so, moving on to, this 3670B argument, I confess I'm a little confused. All we're saying is I think that the replacement regulations acknowledge that one can vest pursuant to a development agreement, which is what state law requires. So all that does is get us back to the textual question: what was agreed to in the development agreement? So again, that is simply part of the textual argument. And again, on the common law vesting, Mr. Yell uses the word common law. I'm trying to use the word case law. I think there is a distinction. But the case law is part of the law of the state of Washington. And this development agreement expressly says it will be interpreted under the laws of the state of Washington. The word vesting had a plain and accepted meaning in 1996. And that plain and accepted meaning is consistent with Shelter's interpretation of the agreement, whereas the city is asking you to adopt non-permanent vesting and period-specific vesting. So, I encourage you in rendering your decision to go back and look at the actual language of the development agreement, the actual words that were used, the definitions, and all that language. It all fits together. It's all of a piece. It's all consistent with vesting as that term is understood in the case law and as the director himself understood it until his position changed with the adoption of the replacement regulations. And I guess the one other, well, I guess I've already talked about it. I think it's really, I think the point to make on the cross motion for summary judgment is that you don't have to reach any of the additional issues. The last three, or I submit last four bullet points, if you rule in our favor on what the plain language of the development agreement means. If you rule against us on that issue, then we have to proceed to address these issues. But there's no need to reach those alternative reasons for saying we're vested if you agree we are vested.
Right. If I grant your motion for summary judgment, we're done.
Yes.
If I deny your motion but grant Mr. Lell's motion, you agree that those three bullet points would need additional analysis?
Well, yeah, I mean, I think it's more like 60 hours of transcript.
The thing we've been trying to avoid, yeah. Okay. Well, that makes sense to me. I didn't want to interrupt your argument there, Mr. Snyder.
No, I think I would repeat myself more than I already have. So
No need for that. Quick question that occurred to me, and I know I knew this at one point. Do any of the I won't say common law, I'll say any of the cases in Washington's case law that predate, Patala, if you will, or older cases, did any of them directly address site development permits? I just do not recall off the top of my head.
Well, my response to that is that a site development permit is like most terms. What meaning that has is dependent on every city defines.
It's jurisdictional. Okay.
Jurisdictional. I think, however, a site development permit is exactly comparable in terms of the issues at play here with the master use permit in the city of Seattle. And in the Erickson versus McLaren case, the city at that point in time, the city has since granted more vested rights because of its design review process and the West Main problem. But back in 1994, I think, or 5, when that case was decided, in the city of Seattle, you could vest by applying for a building permit. You could vest by getting your MUP. The applicant said, you, Supreme Court, ought to extend the case law vested rights doctrine that allows to vest when we apply for a MUP. And the Supreme Court said, no, we're not going to extend the case law because the legislature is, actively dealing with the Growth Management Act and all of that. But the city could certainly do it if it wanted to. And, that takes us back to the exhibit I talked about where the city acknowledges it has a West Main problem if it doesn't let you vest when you submit an application for a site development permit. So it's the ongoing debate about whether one can vest when they apply for a land use permit or when the land use permit is issued. And different cities are dealing with that differently. And Seattle is more liberal towards applicants today than it was when Erickson was decided, for example.
They've been sued several times. Don't worry about it. Okay, did that conclude your argument, Mr.
Yes.
Snyder? Mr. Lell, did you have any further remarks in relation to your motion for partial summary judgment?
Nothing further, Mr. Examiner.
Okay, well, thank you. So, with that then, to be clear, I think everyone agrees that were I to grant the appellant's motion for summary judgment, then everyone can go discuss this further in Superior Court. Were I not to do that, and were I to grant the city's motion for partial summary judgment, we'd all be back here one more time. I have no idea what I'm going to do yet. This is clearly a lot to think about. So I think ultimately the best way forward is I will produce a decision depending on how that goes. Perhaps if needed, meaning if I deny but approve, maybe I will include some kind of order that, appended to the decision. Again, if I concur with the appellant, none of that will be required and the LUPA process can get started. Or perhaps I'll produce something so, in the solemnic would be the word I would think of, that everyone's happy and there will be no LUPA appeal, but I have a hard time imagining on either side that that would be possible. So that said, I do have a lot to consider. I know everyone wants to get this done. I'm going to kindly request that I be granted slightly longer than 2 weeks to produce this decision, but I'll let people make, objections to that.
No objection from the city.
Okay.
And no objection, although I think my client would appreciate knowing how much longer.
Can you give me 3 weeks? Is that reasonable instead of 2?
Yes.
Okay, thank you. We've been very, very busy with appeals lately, which are time consuming, so I will start on this right away, but my decision will be produced here in, we'll call it the next 15 working days. I don't think we have any holidays between now and then, but Ms. Gary, do you have a calendar open? You
Working
can
on it.
Tell me what date this is due.
Well, 3 weeks, of course, is more than 15 days.
I said 15 working days.
Yeah, so let's see, 1st, 8th, the October 15th.
October 15th. Isn't that 3 weeks? They should be coterminous as long as there's no holidays.
I don't think there's any
Okay,
holidays between now
so
and then.
you all should expect the decision by close of business October 15th. Okay?
Thank you.
Great, and I thank you. I thank everyone for being here, for the very professional manner in which everything has proceeded thus far. I don't always have attorneys that are knowledgeable in land use, so it is a joy when I get a whole room of them. So thank you, everyone, and with that, we'll go ahead and close the record.